Hello, everyone. This is attorney Maria Baler of the law firm of Samuel, Sayward & Baler, located in Dedham, Massachusetts, where we focus our practice in the areas of estate planning, elder law, and estate and trust administration. Welcome to this week's edition of Smart Counsel for Lunch. Today, I wanted to talk to you about revocable trusts, what they are, and how they can be used as part of a comprehensive estate plan. So a revocable trust is a type of trust that can be created by a person called a grantor, where in the trust agreement, the grantor designates a trustee, who's the person who would be in charge of managing any assets that are owned by the trust, and beneficiaries, the people who will benefit from the assets in the trust. And trusts can own assets in their name. So this grantor who creates the trust can transfer assets or retitle their assets into the name of this trust. Let's say the trust is called the Smith Family Trust. We can deed the grantor's home into the Smith Family Trust. We can change the title on the grantor's investment account into the name of the Smith Family Trust. We can name the trust as beneficiary of a life insurance policy. And the trust, therefore, owns those assets, and those assets are under the control of the trustee who manages them for the benefit of the beneficiaries. If you create a revocable trust as part of your estate plan, you're typically creating the trust for your own benefit while you're alive. So you would be both the grantor, the trustee, and the beneficiary of the trust while you're alive. And this trust is a revocable trust, which means exactly what it sounds like. It's a trust you can revoke or terminate anytime you want. You can amend the trust whenever you want. If you want to change who the trustee is, you want to change who the beneficiaries are, you want to change the instructions you leave for the trustee in terms of how the asset should be distributed to the beneficiaries, all of that can be changed by you as long as you're alive. And that is a benefit because circumstances change, and you may want to change your plan or your instructions as life goes on. So that's what a trust is, and that's what a revocable trust is. Now let's talk about why sometimes we like to use revocable trusts as part of an estate plan. Trusts can have many advantages. They can allow assets that are owned by the trust to avoid the probate process. Probate is the court process that happens when someone dies and owns assets in their individual name and is required to transfer those assets to their heirs or the people who will receive the assets under their will. If you have a trust that you've created during your lifetime and you have transferred assets into the name of that trust while you're alive so that the trust owns those assets at the time of your death, those assets do not have to go through the probate process. The trustee of the trust or the successor trustee who's designated in the trust can take immediate control of those assets after the grantor dies and use those assets immediately for the benefit of the beneficiaries, or can sell real estate or manage the stock or whatever other assets are owned in the trust right away without any delay. That's a major, major benefit of probate, especially in a state like Massachusetts where our probate process can take several months before a personal representative is even appointed and is able to take control of assets after someone passes. Trusts can also be used to manage assets for beneficiaries who might need assets managed for them after the grantor dies. Maybe the grantor of the trust has young children who aren't legally able to take control of assets because of their age, or maybe the beneficiaries are not mature enough to take control of assets and use them for their own benefit in a way that makes sense or that is for in their own best interest. So a grantor with beneficiaries like that can designate a trustee to manage those assets until the beneficiaries reach a certain age and become mature enough to take control of the assets on their own and use them wisely. Sometimes grantors have children who have special needs or other disabilities that make it inappropriate for them to own assets, primarily because owning those assets might cause them to lose eligibility for public benefits they might otherwise be eligible to receive. So trusts can be used to hold assets for the benefit of those beneficiaries while still allowing them to qualify for or receive public benefits that might be needs-based. Trust can also be used to protect assets. If you have a beneficiary who's prone to liability, maybe because of their profession, or maybe because they don't manage their own money well and they have some creditor issues, or maybe you have someone who's in the middle of a lawsuit, or is in a marriage that's not stable and you're concerned that they might be getting a divorce. If a trust holds assets for the benefit of that beneficiary, those assets will be protected in that trust, much more protected from those liabilities than if the assets were given to the beneficiary directly and the beneficiary owned those assets in his or her own right. So that can be a very important benefit of a trust, especially for people who want to protect the assets they're leaving to their children, or if you have a beneficiary, again, who is prone to liability for whatever reason. Finally, in Massachusetts, trusts are often used as an estate tax savings tool. If you have assets that are over $2 million in value, which is not difficult in Massachusetts these days, if you own real estate and you have a retirement account or a life insurance policy, your value of your estate will quickly add up. We can use revocable trusts that are called credit shelter trusts to shelter assets when the first spouse dies of a married couple in trust for the benefit of the surviving spouse in such a way that those assets are not part of the surviving spouse's estate when we're calculating whether estate tax is owed at the time of the surviving spouse's death. So trust can be used as a tax sheltering tool in that way to save estate taxes or even eliminate them for married couples with assets in excess of $2 million. So that's a really important benefit of using a revocable trust if you have an estate of that amount. Trusts are not just for the wealthy. Avoiding probate is important for anybody with any type of assets. Managing assets for young or disabled beneficiaries is also important regardless of the amount of assets you may have. So keep that in mind when you're talking to your estate planning attorney about your own estate plan. I would urge you to meet with an estate planning attorney, learn more about how trust could be useful in your personal situation, and decide if it's something you would like to utilize. And if so, work with an experienced estate planning attorney to make sure your trust is drafted appropriately, that you get appropriate and specific instructions about how to fund your trust with your assets and how to designate beneficiaries on assets so that your trust will work as intended. And then follow through and actually, follow those instructions and fund your trust so that everything will work as you want it to, and your plan will work as smoothly as possible and protect your beneficiaries as you intended it to when you created it. Thanks for watching. Please let us know if we can answer any questions for you, or if you'd like to schedule an appointment with one of our attorneys to discuss trust planning or any other type of estate planning. Like our videos and subscribe to our YouTube channel if you'd like to see more. Thanks for watching, everyone. See you again next week.